Welcome everyone to adding asset protection to your practice. Thank you for joining me today. I look forward to this webinar. It's going to be very interesting. My name is Douglas Lodmell. I'm the co-founder, managing partner of Lodmell and Lodmell, and we have been doing asset protection since 1997, so 20 years. And we've learned a lot. We have been a leader in developing some of the breakthrough concepts that are still used today in asset protection. I wrote a book called The Lawsuit Lottery, The Hijacking of Justice in America, where I outlined really the fundamental dysfunctions of our legal system. There are many. It works great in some capacity, and it really is flawed in others. Certainly, if you're a client and you have wealth and you get sued and you feel it is unjust, it feels very broken to you. And I know we all have clients where that's the case. I'm also the founder of the Asset Protection Council. And what the Asset Protection Council is it's a network of attorneys affiliated that are really designed to support those attorneys in adding asset protection to their practice. So a lot of attorneys are now looking at asset protection as a practice area that they need to consider. Clients are walking in the door asking about it, and yet they don't have the experience yet to do it. They don't feel comfortable. The Asset Protection Council is designed for you, to help you, to give you the support, to give you the benefit of our 20 years of experience and expertise, as well as the legal tools in a way that you can get to using it right away. So I hope you find this very helpful. The goal for this webinar is really, by the end, for you to feel like you can start taking asset protection clients, that you have a roadmap to follow, that you could look at and say, okay, I actually feel like I could take a client that walks in the door and know what to do with them. So what are we facing? Well, we're facing that nowadays clients understand that the risk of litigation is real, it's growing, the lawsuit crisis hasn't really abated. If anything, it's just gotten more ingrained into our system. What 40 years ago would have been just ridiculous, that would have caused outrage, today is really just standard, par for the course behavior in the legal system, in the courts. I talk to attorneys all the time that said, God, I talked to one in Palm Beach yesterday. He asked me who the other party was for a client that I was working with, and he said, it used to be that I knew everyone and I could pick up the phone and I could make something happen, and I don't know anyone today. I mean, everybody's new. It's a fungible field. Attorneys don't treat each other with respect the way they used to, and they certainly don't see the legal system as a place of last resort. They see it as a weapon of first action. So clients feel this. I can tell you that they feel this. I mean, I've been doing nothing but asset protection for 20 years. Believe me, the energy today when I talk to a client versus 15 or 20 years ago, you don't have to convince them. I spent many years just explaining the system and helping clients understand the risk. Today I spend zero time doing that. Literally. They walk in, the risk is absolutely front and center. They do not need to be convinced that they need asset protection. What they need now is they need clarity, because asset protection has become very confusing. It is not clear to them what the right course of action is. So my goal is for you to be that source of clarity, that source of information. Your job as the asset protection attorney is to do the homework for them, so that when they walk in and say, well, I've been reading about Nevada trusts and Nevis LLCs and offshore Cook Islands, and I don't know what to think of it all. We want you to be able to explain it to them, to bring them the context and say, here's the way that I recommend that you do it. And that's the goal, and that's what you'll be able to do once you begin working with the Asset Protection Council. So I'm going to talk a little bit about, if you haven't added asset protection to your practice yet, think about embracing it as a core competency of your practice. Think about making asset protection something that you really do. Asset protection attracts better clients, better estate planning clients, higher end clients. It leads to a more complete estate and business plan. I have one affiliate attorney that he leads with the asset protection. That is his absolute lead. But ultimately, what he really is most interested in helping clients with is their business planning. and he is extremely successful in using the asset protection to get them in the door, completing the asset protection, but then turning that into really billable business for him. And in many cases, it leads to litigation, which is another part of his practice. So depending on the style of your practice, asset protection can just be a great front-end lead for you because that's what clients care about. It's sexy to them. And of course, asset protection, certainly if you're just doing estate planning, asset protection is a much higher price point. Estate planning, $5,000 to $10,000 for, a typical simple estate plan, maybe even less. Asset protection, 20 to 30 and up. So you're really talking about a different price point, and you will find that the same people, the not extremely wealthy people, will be happy to pay $20,000 or $30,000 for an asset protection plan to protect 2 or 3 or 4, because that's real to them. People have an inherent fear. Their sensitivity to losing what they have is much higher than their desire to get what they don't have. And there's plenty of studies on that. People will literally put far more value on not losing what they have versus increasing, in a gain capacity. So asset protection hits right on that point. It's very visceral for clients, and it's very apparent. Clients need it and want it. They do. They just need it and want it. This is more true today than it has ever been. They need it, they want it, and they're either going to get it from you or they're going to get it from somebody else. So it might as well be you. You might as well be the one that can give them the quality service and the right tools and keep the business in-house. You can use asset protection to drive your growth. And like I said, lead with asset protection, the estate, the business, legal work, insurance, CPA work, all that follows. And inside the network, we have mostly attorneys, but we also have CPAs, financial planners, advisors, other professionals that are interested in using asset protection, again, simply as a lead into their other side of the business. And it makes sense. Asset protection can and should be integrated into your marketing efforts. Again, it's a lot sexier to talk about asset protection than it is to talk about estate planning or returns on your investment. All of those are old conversations that everyone's kind of heard. Protecting your assets is not an old conversation. I'll also share with you that we do something different here. This is not a transactional practice. It really isn't. It's a relationship practice. The vast majority of the clients who have ever been clients with us are still clients with us. And that's because the way we structure it, and this is different. A traditional estate planning business in the past has been very transactional. You do a trust, or you do a will, or you do an LLC, and it's kind of done. And you don't really keep in touch with the client. You just hope they come back if they need you, but there's no continuing relationship that's built into it. This has started to change, but it certainly hasn't gotten to the point that it can be. And this is where it needs to be. So our advice, and what we've certainly done, is establish a long-term relationship as a fundamental part of them engaging you. In other words, right in the front. So the way it works is that these are the legal fees. Here is the annual fee. Create a package of ongoing services that are covered by that annual fee so that they continue to feel like there's value exchanged every year. Drop the idea that your practice is transactional. I hope I'm preaching to the choir here. I'm sure for some of you I am. For others, I'm guessing that this is not new in concept, but that you're still doing it the old way. You still have a transactional practice. It's time to drop that. You really have to get into the world of a non-transactional practice. The transaction is only a part of what you do. Relationship is what matters. That's what you want. Charge an annual maintenance fee. I don't care if you're only doing a revocable living trust or even an LLC. Doesn't matter if the annual maintenance fee is $100. It's got to be something, because believe me, it will connect you to your clients. They will stay. They will feel even a small fee will engage them as thinking that they have you on their team and as a resource. And that's what you want. Part of my annual fee is that I don't bill by the hour. So I tell my clients, call me anytime. And anytime I get an email or my assistant says, Dr. So-and-so called and he had this question, I say schedule a call. Because I see every communication with my clients, every opportunity I can get to interact with them, increases and strengthens my relationship with them. That supports my annual maintenance fee, which is an annuity for the practice, and a benefit to everybody involved. So I cannot stress enough how valuable this is. In fact, it gets its own slide. It's so valuable. The annual maintenance fee keeps you connected to the clients and their family. It's much easier to sell than an hourly fee. Nobody likes being billed by the hour. Nobody likes an unspecified, undefined amount that they're going to owe each month. There's exceptions to that. I think it's difficult in the litigation practice, unless you're on a contingent fee, to not bill by the hour, and that's different. But for transactional or estate planning, and certainly asset protection, a fixed annual fee is much better. Clients are willing to pay it, and in the end, I think it works out better for you as a provider. And it gives you a chance and puts you in a position of responsibility to make sure that stuff really is maintained. And that's important, because we know clients are not going to maintain their tools, not alone. We have to be there at least to be the voice of reminding them that they need to fund it properly, they need to make the transfers, if not do it for them. So it's just better for them, and certainly better for you. I definitely recommend that you systemate and automate using a CRM, which is a customer resource management software system. If you're not on that, I have a whole different webinar that's nothing but talking about the tools of running your practice. It's at assetprotectioncouncil.com under the resources page. I definitely recommend that you watch that as well. If you're not using a CRM, if you can't email every client with about 3 clicks of the button, then you are well behind the times, and it's critical. You need to do it. We're not talking about Outlook either. You can't say, yeah, I can email everyone through Outlook. That's not a CRM. It needs to be something like Infusionsoft or Salesforce or Constant Contact, or something that can give you defined capacity to email them information, schedules, follow-up systems, programs. We use our system just as much for fulfillment of our legal work with them as we do for marketing on the front end. A good system will do both and make your life much easier. Trust me, much, much easier. And again, the annual fee becomes an important source of recurring revenue. It may seem like it's a small thing the first year when you only have 40 people on it or 50 people on it, but after 10 years or 20 years, when you have thousands of people paying you an annual fee, it becomes a substantial part of your revenue. Certainly makes your practice more valuable if you would ever like to transition it or sell it, bring in a partner, etc. It changes the dynamic that you have with your clients. They are your current clients. Clients from 15 years ago, for me, are my most connected, valuable clients. I know them the best. I've been talking to them at least annually for 15 years. You ask a normal estate planning attorney, can you give me a list of your clients you did 15 years ago and tell me when you last spoke to them? He's going to say, no idea. I don't even know who I worked for 15 years ago, and I'm certainly not still talking to them. When you realize you're not doing something, don't worry about the past, just start doing it. So if this is hitting you going, gosh, I wish I would have done this 10 years ago, don't worry about it, just start. Just pick it up from here, and believe me, it will then become the thing you do, and then it will become valuable to you. And again, all this I am happy to help with. Part of what we do in the Asset Protection Council is some of this coaching around how to create a modern style law firm with systems that work. And the main part is really how can you get access to the expertise in asset protection tools themselves. And that's what we're going to spend the rest of the webinar on, is really talking about the asset protection tools and how you can use them. So here's what clients want when it comes to asset protection. Here's what they want. They want it to be effective. Needs to have effectiveness. Otherwise, they don't care. If you tell them, I've got something, it's not great, but it's something, they don't want to hear it. They want control. Surprise, surprise, right? They want control of their assets and their entities that control their assets. They want the costs to be as low as possible. So, everybody does, and it doesn't matter how wealthy they are. And they want a minimum amount of compliance and tax returns and reporting. It's just got to be simple. I could have put simple there just as well. So it needs to be effective. They want to be in control. They don't want it to cost an arm and a leg, and they want it to be simple to maintain. I'm going to go over 3 tools. 2 of them you certainly are used to. 1 of them may be new to you. The tools are a limited liability company, an asset management limited partnership, and then the asset protection trust. So we all are familiar with the limited liability company. We know what it does. It protects risky assets. It insulates and segregates assets. So this is good for rental real estate that a client owns. You might have a portfolio. In fact, just before this call, I talked to 2 clients. They have $6 million of rental real estate, and they've got it in LLCs, and they came in the door like that. And I said, great, you did the right thing. They segregated it into about 7 different LLCs, so just under $1 million in each LLC. That's about right. You know, some clients feel more comfortable with less, some could do more. But it's a great tool for things like businesses, real estate, even assets that people use like their boats and their cars and their airplanes. Certainly you'd want an LLC around all that. We're all familiar with the charging order effectiveness around an LLC and how it creates a barrier. So that's pretty standard. The second tool is the asset management limited partnership. You might be thinking family limited partnership. You would not be wrong. The difference is that with an asset management limited partnership, we are very much designing this for asset protection. So the provisions in it are very much dialed into asset protection. So it's protecting the partners from an attack from the outside. In our structure, this is the family holding company. This is where we're going to consolidate the vast bulk of the family assets. It holds the LLCs and the other companies, as well as the cash and the investments and so forth directly. We use Arizona. The reason we use Arizona is a pretty live free or die state. Get out of my backyard or I can shoot you. Don't come across my border type of state. They are very good about protecting the charging order as the exclusive remedy. We've had a case in Arizona where even a single member LLC was protected. Very, very clear facts that in some other states would have pierced right through that LLC, and Arizona was preserved. So we like Arizona. We also like that oftentimes it's not the client's home state, in fact, most often, and that's good. We like to have a diversity of jurisdiction. We don't want everything to be in the client's home state. And again, you can include your family members, but most importantly, you can include the asset protection trust, and that's the key. We can also add privacy to the asset management limited partnership by creating a Wyoming-based LLC to serve as the general partner. We don't do this for every client, but we do this for clients where that's important to them. So if having a layer of privacy, so if someone looks up a property address and they see the owner is an LLC, and then they see the owner of that LLC is the limited partnership, they're going to run into a dead end there if we set it up with the Wyoming LLC as the general partner, because in Arizona only the general partnership partner is listed, and if the general partner is a Wyoming LLC that does not show who the members of that are, which is allowable in Wyoming, then they run into a dead end. We all know that this doesn't prevent them to going into court and getting the client to reveal all these structures, but it does prevent the casual looker from reverse engineering and trying to figure stuff out. And certainly for some clients that's invaluable. All right, so here's the big tool. Here's the one that you may or may not be familiar with. And so we're going to spend really a little bit of time on this to make sure that you really get a sense of this particular tool. The key with an asset protection trust is that the assets can be moved outside of the U.S. legal system. It radically enhances the domestic structures. It's not limited to any specific risk. It very much protects all the assets held by the trust. It's again can be very private. It's not something that even needs to be on the table at all when you're talking about. It doesn't get revealed until you're ready to reveal it. So I'm going to explain, because there's a lot of confusion about what an asset protection trust is. It's not necessarily just that means only this one thing. But I'm going to give you the history so that you get a sense of what today people mean when they say asset protection trust. It's a self-settled spendthrift trust. That is the primary definition which distinguishes an asset protection trust from another type of trust which may also protect assets. like a non-grantor trust, an irrevocable trust. You can have other trusts that also protect assets. But an asset protection trust in the vernacular we use today really means a self-settled spendthrift trust, which means a trust that is settled by the client for the client, just like a revocable living trust is also a self-settled trust, but with spendthrift provisions which prevent the client's own creditors from reaching the assets. So there's two schools of thought when it comes to self-settled spendthrift trusts: international or domestic. International. This was first. And I can tell you, before 1984, this wasn't even a twinkling in your father's eye, as they say, right? I mean, having a self-settled trust with spendthrift provisions was not something that a single U.S. lawyer had ever seen. It didn't exist. It was created by statute in 1984 in the Cook Islands. That was the first jurisdiction, Cook Islands Trust Act in 1984. And it was designed specifically for clients to protect assets. It was very much a purpose-driven statute drafted by lawyers for lawyers to protect client assets. The very first part of the statute is that there is a statutory non-recognition of any other jurisdiction's court orders or judicial proceedings. That means in the Cook Islands, if you come down with a judgment from any other jurisdiction in the world, it's worth zero in the Cook Islands. Zero. So you cannot take your hard-earned judgment and get the benefit of coming down to the Cook Islands and domesticating it. It's not possible. They are prohibited. That means you have to start the case over again, which is a very big deal, especially when you now are dealing in a system where they have decided for a civil case, you need to prove your case beyond a reasonable doubt, which is the highest possible criminal standard. That's the murder standard. That's the 99% sure standard. That's a very high burden. So just imagine trying to meet that burden in a civil case. It would be virtually impossible. And they don't accept contingent fees in the Cook Islands. So you're not going to be able to get a lawyer for free down there working for a cut of the action. Not that you'd be able to find one with, it's so difficult to establish beyond a reasonable doubt your case, but you're also prohibited from even trying. So that means you're going to have to get your checkbook out and you're going to have to fund your own case down there. Once you file your case, you cannot amend your case. So the fishing expeditions that we're so common and so used to here in the States, where you file, you think you know more or less what you are filing about, but you're gonna hope to discover a few more causes of action and claims once you get into discovery. That doesn't work down there. You cannot amend a claim once you file it. Also, if you lose, which, as you can imagine, with that burden of proof and these hurdles against you, you probably will, you're going to pay the legal fees and costs of the winner, which is very likely to be the guy who's protecting his assets. Statute of limitations is very short, 2 years for general and 1 year for fraudulent conveyance. This basically means even if they're within the statute, which is very hard to get within the statute, if you're not in the statute, you're precluded from even filing the case. Even if you got down there within the statute, you filed your claim, you lose, but you find 3 more things that you probably feel are good arguments and you want to go and refile, the statute's then run, so now you're precluded from refiling. The bottom line, and I think you probably have all heard this if you've done any research on asset protection, is that an international trust is extremely, extremely effective. That's its greatest strength, is effectiveness. It really is effective. And I can tell you, I have been involved in this for 20 years. I have personally had over 100 cases where we have had to trigger our trust and turn them into international trusts and use them for actual defense, and they have all worked. It's just very, very effective. So what are the costs or the drawbacks? Well, first of all, when you do that, your client certainly can't be in control of the trust. It'd have to be the offshore trust company in control of the trust. Otherwise, the judge can just simply direct your client to bring the money back, which we don't want. It's certainly going to cost more than your average trust. It's not going to be an estate planning trust. It's not even nowadays going to cost what a domestic asset protection trust is going to cost. Typical cost is somewhere between $25,000 and $50,000 and up for an offshore trust. And compliance. As soon as you have a foreign trust, you are under the foreign trust reporting requirements. That includes Form 3520, Form 3520A each year. If you do have offshore accounts associated with the trust, then you also are subject to the FACTA disclosures, the FinCEN 114. None of these require or create an extra tax. It's not creating more tax. It is just creating more compliance. However, if you fail on your compliance, if you fail to file the 3520, you could be subject to a penalty which could be up to 35% of the trust assets. So inadvertently, it could be a tax. It just means that you have to be very intentional and serious if you're going to use an international trust. What this means is that for a lot of average clients, this may be a little too much for them. It just may come with too much requirements of cost, compliance, and control for the benefits. Comes to the domestic option, and those drawbacks really are what have driven the domestic option. The domestic option is newer. Between 1984 and 1998, attorneys were kind of in the middle on, well, I know that these things are happening offshore, but domestically, I don't think I think we're going to get some court saying that this is against U.S. public policy, and they're going to somehow void all of these offshore trusts in one fell swoop. Well, that never happened. In fact, what happened is the opposite. Alaska said, wow, these trusts have been around offshore for over a decade, and they're starting to become more popular, and the business is all going offshore. We could use some business up here in Alaska, and why don't we create a statute? And so they did. And they tried to the best of their ability to mirror the offshore statutes. And so, of course, if Alaska is going to do it, Nevada's not going to be left out. Delaware's not going to be left out. And then Colorado, Hawaii, Mississippi, Missouri, Ohio, Oklahoma, they all jumped on board and said, hey, wait a second, us too, don't leave us out. Even Tennessee, Virginia, I mean, it's like a third of the U.S. states now have some form of domestic asset protection trust statute on their books. That's the good news. The good news is that I think it's pretty clear with a third of the U.S. states saying this is actually a great idea. We don't have a public policy issue with somebody saying, hey, this is just fundamentally opposed to our U.S. sensibility. No, it's not fundamentally opposed. This is actually okay to do. So what are the advantages of the domestic trust? Well, cost. Many more attorneys got comfortable with it. Some of the estate planning and document preparation software started integrating domestic asset protection trusts into their documents online or documents on their platform, which made a lot of attorneys feel more comfortable doing them. Certainly working in Nevada or Delaware or South Dakota was more comfortable for an attorney than working in the Cook Islands or Nevis or Belize. And so the cost came down because a lot more people provided them, and it was easier for lawyers to feel comfortable to access it. Compliance. There's no foreign component to this, so there is no foreign trust compliance. There's no 3520, and there's no 3520A. There's no FACTA disclosures because there's no offshore bank account. So a lot of people actually have gone this direction and said, well, let's just go domestically. It's it's less expensive, it's more comfortable for clients, and there's less compliance. That's the good news. What is the bad news? Well, the bad news is that they don't work as well. We have more cases where the domestic trusts have failed completely, and that makes sense because the one part of the foreign statute that Alaska, Nevada, and Delaware could not import is the non-recognition of another jurisdiction's judicial proceedings. We have Article 4, Section 1 of the Constitution, which says the states shall grant full faith and credit to each other's laws and judicial proceedings. So if a client gets a judgment from a California court and goes to Nevada, Nevada can't say, oh, sorry, we don't recognize that judgment, start your case all over. No, they say, fine, here's the domestication process. Very simple to domesticate a judgment from another state, and then you're right back into court. And we have cases where even two asset protection jurisdictions like Utah and Nevada, it has failed between. So a family court in Utah, which also is a domestic asset protection trust state, said, well, we're not going to apply the Nevada trust law where this trust is set up. We're going to apply Utah law, and we're not going to apply Utah domestic asset protection trust law. We're going to apply Utah family law, and we're just going to disregard all this asset protection. And I'm going to recast this. And because it is in the hands of the court, there's not much you can do about it. So I'm not telling you that there's never a time for a domestic asset protection trust. There definitely is, and are situations. If the client lives in the state, if the facts are just right, a domestic trust may be enough. But it is definitely not the foolproof solution for all clients at all times. And the various trust companies in the various states that are drumming the business and working to make their state good would like to say, yeah, come to my state. And what I've seen happen in practice is that these trust companies are actually getting more picky, that they first got into it and they wanted a lot of asset protection business, and now that it's become an uncertain area of law, they've actually wanted less of it. So it is definitely not the solution, and I can tell you clients themselves come in the door, and they usually come in the door saying, I'm calling you because I've already done my own research and I don't want a domestic asset protection trust. So clients it's very easy online to figure out that the domestic is not as strong as the offshore. The other disadvantage is control. So you may think, wait a second, this is domestic, why is control a disadvantage? Well, if you're going to use a domestic asset protection trust, then you need to be stricter in your drafting than you are if you're going to use an offshore asset protection trust. Why is that? Because you have to now convince a judge that this domestic trust should be respected, and part of that is to get your client fully removed from any kind of appearance of control. So you're going to actually have to convince your client that they need to be far away from the control elements of your domestic asset protection trust, and clients don't like that. We talked about the 4 things they want. Control is one of those things. So for those 2 reasons, effectiveness and control, I personally do not use or recommend a domestic-only asset protection trust. I just think there's a better solution, so why go with a second-tier solution when there's a better solution? So what is that better solution? That is what I call the bridge trust. And the bridge trust is something that we've been using for 20 years. We created it. This is our creation. It is unique. It is branded. It has got quite a lot of traction in the world as far as how people understand it and see it. And we've got literally hundreds of attorneys throughout the country that work inside of the Asset Protection Council and use the bridge trust. It is very good. And the first thing that affiliate attorneys say when I'm on the phone with them and their clients is, I looked everywhere, I did all the research, I researched offshore, I researched domestic, and this is the tool that I have found that I consider the best, which is why Doug is on the phone with us today, because I want him to explain how the bridge trust works for you. That is the most common introduction I get when I'm working with an affiliate and with their clients, and it is true in every case that they say it. So what is a bridge trust? It's offshore level of protection, but with domestic simplicity. So there is no IRS Form 3520 or 3520A. There's no FinCEN or FACTA disclosures because the trust is not an offshore trust. It is a bridge trust. So it is registered offshore in an offshore jurisdiction. But for purposes of 7701A30E, which defines what a domestic or a foreign trust is, we meet the 2-part test. The 2-part test is that the U.S. jurisdiction has to have primary supervision and control over the trust, and a U.S. person has to have primary control over the trust, in other words, in the role as trustee. So how do we meet that? We recite and define in the bridge trust that it is a domestic trust. We will either use the jurisdiction of the client if they live in one of the 16 DAPT states, or we'll use Nevada. We will recite Nevada. That gives us domestic jurisdiction. How else do we do it? We make the client the trustee of the trust. What this means is that it is a domestic grantor trust for U.S. tax purposes and for U.S. IRS purposes, which means no IRS filing requirements of any kind whatsoever. Assets can remain right in the U.S. with the current bank, current financial advisor. Believe me, our job is not to go and convince a client to change their financial advisor. That's not the business I want to be in. I want to give them a wrapper to protect their clients' assets, and I want to partner with their financial advisor. That's why financial advisors are invited and often are members of the Asset Protection Council themselves, because their clients are coming to them asking for, hey, I know you're doing a great job of getting me a return on my money, but how do I protect it? It's actually something that they come a lot to the table with as a question. There's no requirement for an initial foreign trustee. Why? Because the client can be their own trustee. This is a huge point for the clients. They really want to be their own trustee. They like this. They understand this and they feel comfortable with it. A lot of clients just don't feel comfortable with the foreign. They want the protection of the foreign, but they don't want to deal with all the foreign drawbacks of control and maintenance and so forth. Once they see this, they say, got it. That makes sense to me. It's a tax-neutral domestic grantor trust. It's literally ignored just like a revocable living trust is from a tax standpoint. So let's test this with our 4 things. Is it effective? Yes. Why? Because if we ever have a client that actually has an event of duress, meaning they get sued or they have a problem, guess what? The trust, the bridge trust, becomes a fully foreign Cook Islands trust. That's built into the trust. It's already there. All it takes is a declaration of an event of duress by the protector. So it's a discretionary thing. It's not automatic. But once the protector declares that an event of duress has occurred, whether that's a lawsuit or just the client's feeling so nervous about what's going on that they want to trigger the trust. Some clients call me, actually every election, they call me before the election and they're always nervous. And it doesn't matter who they're worried about. It's just change makes them nervous and they want to trigger the trust. We usually don't, by the way. I usually talk them off the ledge and convince them that you don't need to trigger the trust right now. But that would be enough if they really felt that uncomfortable. And I typically serve as protector for the trust, and I will declare an event of duress if that's really in the interest of the trust. So it is effective because it becomes a Cook Islands Asset Protection Trust, the strongest type of trust that I know of in the world. Control. Well, we've already said the client can be their own trustee. That is huge, and that makes the acceptance on the client level very easy. They accept this extremely easy. Cost. It is in the middle of the road when it comes to cost. The bridge trust is $23,000. There's a $2,100 annual fee with it. That's right down the middle of the road when it comes to cost. And again, that price point is in my opinion dead on. It's perfect. It's not, you know, it's not $12,000, which you really, there's nothing for $12,000 that compares to it, but it's not $40,000 for a fully offshore trust with $5,000 or $10,000 a year of maintenance. And compliance, there's none. I mean, as long as the trust has not been triggered and turned into the foreign trust, then there's no compliance whatsoever because it's a domestic grantor trust. Very simple. So let's look at how this all gets put together. Asset Management Limited Partnership is the centerpiece to the plan as far as the accumulation of assets. Those little houses are LLCs, and they are going to be used for real estate and boats and airplanes and all those types of assets that clients have. There's the bridge trust. And then you're still going to have your revocable living trust. This does not change the need for a revocable living trust. So how does it all fit together? Well, the limited liability companies are owned by the Asset Management Limited Partnership. The Asset Management Limited Partnership is controlled by the client. The client is the general partner. What else can go directly in the Asset Management Limited Partnership? Cash, stocks, bonds, collectibles, receivables, any kind of securitized asset. So in general, you're going to have the bulk of your client's assets inside the Asset Management Limited Partnership. That gives us the charging order protection, that first layer. Who's the general partner? Well, it's either the client or the client's LLC, depending on how we determine is best to structure it. Who's the limited partner? The bridge trust. Let's call it 98% for our example. So what happens? If the client dies, the assets need to pass. Well, how do they pass? They pass by the bridge trust pointing down to the revocable living trust and directing that the assets get distributed to the revocable living trust, and that handles the distribution for the clients, distributes their assets, maximizes their estate tax exemptions, avoids probate, and smoothly passes their assets in a private way, which is what they all want. Okay, let's reset. What if we have an event of duress? In that case, the assets go to the bridge trust, which they already are owned by. Remember, the bridge trust already owns the 98% interest, and offshore if necessary. So they can literally be sent out of the country. At that point, the offshore trustee becomes the full trustee. At that point, the client's fees and compliance will go up, because at that point we're going to have a foreign trust. So they will have 3520, they will have FinCEN and FACTA disclosures, and they will have a loss of control to the trustee. However, let me tell you from experience, clients are much more flexible when they are looking at losing all their assets. All of a sudden, they don't have any problem with it. They are completely fine with giving up control of the offshore trustee. And again, we have a very clear system for helping the clients understand how the checks and balances work to make sure that there is no chance for a rogue trustee to run off with their money. That's often their first question is, what if the rogue trustee just runs off with my money? Well, the answer is they can't. They don't have that sole authority to move the money out of the bank that you have selected, that you have a relationship, that the bank understands you are the underlying beneficial owner. And by the way, I think it goes without saying, but I'm going to say it, none of this is tax motivated. The client will always pay all of their taxes. Even if the money is sitting offshore, it is still taxable. Worldwide income, it is part of their client's taxable, and if they get capital gains or interest or dividend income, they will pay their taxes on it, and the bank will give them a 1099. The bank is going to report each year to the IRS all of the U.S. clients that it has in its portfolio. So this is completely on the table, above board, and reported, every bit of it. It's just off the table when it comes from a legal standpoint, from an asset protection. So what's the takeaway? Takeaway is keep it simple. Don't overcomplicate this. Identify who in your current client base, you probably are already thinking about people. And let me give you the profile. It's $1 to $5 million and up. That's the net worth for these clients. Some of you may be thinking, wait a second, did he say $1 to $5 million of net worth? I can't imagine a $1 million net worth guy spending $25,000 to protect their assets. Well, think again. $1 million is in fact more likely to have someone under $5 million do this planning than over $25 million. And the reason is that the guy who's spent the last 30 years as a dentist or as a contractor building wealth, and they have $1.8 million of total protectable net worth, how worried are they about losing any little bit of that? The answer is very worried. For them, spending $25,000 to protect that is not really a big decision. And that is the vast majority of my clients are in that $1 to $5 million net worth range. Over 5 million, over 10 million, it's kind of a no-brainer. If you have clients at that level, you should simply be calling them saying, hey, John, we need to talk about asset protection. It's a real thing. It's something that we haven't talked about before, and we need to do it. It would be silly, and I would feel horrible if you got sued and we ended up losing any portion of your assets because we didn't take steps that we could have taken. That should be an easy call. But the $1 to $5 million is even easier, because believe me, they can't withstand even a $200,000 or $300,000 judgment without affecting the way that they see their lives, their retirement, how long they're going to work. So if you're thinking right now, you should be thinking of people going, oh yeah, I have 3 or 4 clients that I right away would like to introduce that to. Schedule a call. I do all the calls. I'm the attorney. When we work together, what typically happens is you will call us. We will debrief the case. You give me an idea of who the client is. I'll talk about it, and I'll say, okay, well, that sounds like this is what we would be recommending. Let's schedule a call with the client. We'll get on the call with the client, and then I'll do the analysis. I'll do all the work because this is obviously, it's going to be the easiest for me to do it. We'll do an analysis. I'll make a recommendation to the client, and then it'll be up to the client to move forward or not. More often than not, they do move forward. It's just not. This is a very, very, very easy area of law to have clients, because you are giving them something that they really makes a difference in how well they sleep at night. And if you can have both the husband and the wife on the call, I strongly recommend it. The wives are typically even more sensitive to losing the assets, often, especially if the husband is the primary business owner, and it's even more important, and they will usually drive the decision even more than the husband will. So it is just get that analysis scheduled on the phone is the best first step you can take. It's also the best way for us to begin working together and actually, for you to see it firsthand, for you to actually see how the process works, understand how the clients work. The way it works is that we co-counsel the case, so we will be working on the case together. The client will sign a retainer agreement identifying both of us. They understand that the fee is going to be shared. The initial split of the fee is 25% to you as the initial first 5 deals. After 5 cases together, you will have a much higher degree of confidence and training over what you're able to handle, and we actually move that split to 40%. So it works very well. It is a great source of revenue for you. It is a great service to provide to your clients. We will make you look good, I promise. We're very good at this. I'm very good at not just the underlying work and designing and giving you and your client an incredibly good plan, but I'm very good at explaining it to clients and answering their questions and helping them understand how it works and how it's going to work in their case all the way through and all the way through to the end, through funding. We just make you look good. So questions, I see there's already a couple of them popping up, so I would encourage you to take right now and type in some questions in the question box, and I will answer as many as I can get to. And before I get to the questions, I want to invite you to join the Asset Protection Council. So you can go to assetprotectioncouncil.com. There is a download. You can fill it out the application. It's very straightforward. I can tell you what I'm looking for is attorneys that after this webinar, you say, yes, I want to learn more. We have cases, we have research, I have webinars. If you could probably spend 20 or 30 hours on assetprotectioncouncil.com under the research resources tab, and believe me, it would be a huge education into the asset protection world. Of course, also, you have access to me. So you can schedule a call with me at any time. We can talk about, in general, the system. There is no fee to join the Asset Protection Council. It is free. My goal is that we will do cases together, and that by working together, we will have more business for all of us. So there's no fee to join. My philosophy is simply, get everybody educated. Whether you want to turn this into a major part of your practice or whether you just want to have the resource of knowing, look, I know who to call when the asset protection client walks in my door, either way is fine. And I will spend as much time with you as necessary to support you whichever direction you want to go. So let's move to some questions. Okay, so is APC membership free? Yes, I already answered that. So it is free. There is no cost. I would strongly encourage you to join. Also, I refer a lot of business back out. I do not do estate planning. I don't do revocable living trusts. I don't do the business planning and all of the stuff that you probably do or many of you do. And where do I turn when I need to refer a client? I turn to the council network. That's where I turn. I literally, and I'm not kidding, I go to my own website, I go to the membership page, and I look up who's in that state, and that's who I make the referrals to. I can guarantee you I have some affiliates that I have referred 3 times as much to them as they have referred in for asset protection. Just happen to work out that way. So if you have a special skill, if you have a special area of practice that you would like to highlight, you're invited. The Asset Protection Council website is a website that will publish your site, publish your papers, publish your commentary on what's happening and what you do. So it is a way for you to get yourself more out there. So it's a resource to help you provide increased higher level services to your clients, and it's a way in which you can market yourself. Okay. A question says, how many times has a bridge trust been sued that you know of and lost? Okay, so my clients who have bridge trusts have been sued dozens, if not hundreds of times. So I have a lot of clients, and so they certainly get sued over the years. How many times has that lawsuit turned into a direct attack on the bridge trust? It has not. We have not had any clients that have had their lawsuit turn into a direct attack on the bridge trust. Here's why. Because By the time it gets to that point, we have removed the economic incentive. We have gotten the asset out of harm's way. And the percentage for them to try to turn their case, which already took them great time and effort to establish their underlying claim, is now becomes apparent that it's not worth it. So while we have lots of clients that get sued on a regular basis, we have as yet to have any of those lawsuits turn into a direct attack on the bridge trust, and certainly none that have forced any extraction of assets from the bridge trust. So it is just, and that's mostly a function of the fact that it's good strategy. The bridge trust gives you a strategic advantage. And I explain often the difference between strategy and tactics. Strategy is the overarching plan that allows you options, that gives you options. Tactics are specific tools that are meant to accomplish a specific goal. So a good strategy will give you many tactical options. So having the bridge trust is a strategic implementation of a tool, because the bridge trust is not yet a tactic. It's a strategy. Triggering the bridge trust into a fully foreign trust is a tactic, and we may or may not do that at any particular time given any particular circumstance. So it becomes very important that you distinguish, and what I see a lot of other attorneys and planners do is they focus on tactics, and they try to implement tactics for their clients without a strategy. And so they say, oh, no, the best tool you can have is an offshore trust with a Nevis LLC. That's the best. Well, it may be the best in the right circumstance, but it may not. And if you just go straight to tactics, you're very likely to make a tactical error at some point. And oftentimes we don't need to go to expensive tactics or complicated or convoluted tactics when we have a good strategy, because the strategy allows us to negotiate with potential plaintiffs or creditors in a much different way than just having a tactic in place. And there's some real disadvantages to some tactics. I mean, they're just outright, a disadvantage, except for very narrow circumstances. So the bridge trust is, from what I know, is the best strategic tool available, because it doesn't commit us completely into being an offshore trust. It gives us the option to become an offshore trust, but not the obligation. And that's a huge distinction, a very, very important distinction. But it's a great question. I see there's a follow-up question. Are there some assets that should not be put into asset protection accounts, like retirement accounts? Yes, great question. Some assets just do not belong in asset protection structures because they are not allowed to be. So retirement plans are a great example of that. So retirement plans, 401ks, IRAs, ERISA, all of those are not able to be put directly into an asset protection trust because they're in a retirement plan. It does not mean that we don't have some tactics that we can use to enhance the protection of some IRAs or some qualified plans, but in general we don't need to turn to those tactics because, as you know, qualified plans by and large are fairly protected. There are some exceptions to that. IRAs in certain states are kind of mushily protected, meaning they don't give us a clear absolute around them. In those cases, if we had, for example, a client with a very large IRA in California, we may use an additional tactic to make that IRA much more difficult to reach. But that would again be tactical based on when we actually need to do it. So great question. Okay, I have another question. Do I have monthly webinars? Yes, this is a monthly webinar. This is an introduction webinar. Once you've been introduced, you can sign up for the council and you'll have access to our monthly webinars. I do a first Thursday webinar on a different topic every month. So the first Thursday of every month, I do a webinar, and it is about various things from the legal to the marketing side of it. They're very good. They're very well attended and followed, and I strongly encourage you to sign up for the Asset Protection Council and begin to join me on the monthly webinars. I also would like to invite you there's a LinkedIn group you can follow, and that links you to the community of members, as well as going to the Asset Protection Council itself, and you can see all the members. You're welcome to call anybody on there and say, hey, how's this working for you? How's Doug? Is he the real deal, or who is he? I have LinkedIn referrals or testimonials from clients. I sent an email out a few years ago and said, hey, I'd love a testimonial. I think I got 49 testimonials within a week from clients that were all just very complimentary. I can tell you that this is a practice area that I am overjoyed to be a part of, because it is so rewarding to help a client protect their assets. And when we actually have to use the asset protection, it's really rewarding when we win, when we do protect the assets, and clients are forever grateful. So I hope this has been extremely helpful for you. I certainly enjoyed doing it, and I invite you to call and schedule a call with me. I would encourage you to just sign up as an Asset Protection Council member and then get started. Start thinking of 2 or 3 clients that this may be appropriate for. Schedule a call with me, and that way we can get some one-on-one time. You can ask any additional questions, legal, marketing, any area you would like, and we can certainly talk about your clients, your potential clients, and come up with a game plan to get some analysis scheduled and hopefully begin working together right away. So thank you for your attention. Everyone, have a great weekend, and I will look forward to seeing you on the First Thursday webinars.